As an in-house legal counsel, it can be quite challenging managing the pressures of your everyday work and projects that have tight deadlines within the business versus a litigation and dispute matter where you might need to bring a claim very quickly or defend a claim because it's arisen out of nowhere. Having worked as an in-house legal counsel and now as a litigation specialist, I've put together a couple of tips on how to best project manage the litigation dispute process so that you can get the best results for the business. The tips are to be clear on the roles and responsibilities during the process, to understand the commercial drivers of the dispute and to give the dispute commerciality so the business understands that, to identify the universe of materials and evidence you need to manage, to be prepared for discovery, and to be conscious of legal professional privilege. So before you jump into sending too many emails or engaging too many stakeholders, you really need to sit down and think who needs to be involved in the actual process of the litigation or the dispute and who needs to be involved from a decision-making process. Now, your company might already have established authorizations and delegations, but otherwise that is something you should create or establish very early on and be clear on, because it is important to have an objective decision-making process. If you don't establish your team early on and project manage the matter well from the start, you could find yourself making decisions that are not authorized. You could find yourself making decisions that are not in the commercial interest of the business. You could find yourself making decisions that financially the business is not prepared for. So when thinking about some of the different stakeholders involved in a settlement, for example, you might have the CEO or a managing director signing off on the ultimate settlement decision. However, you also need to align with potentially with finance and tax on the tax implications of a settlement offer and also on the finance implications, because there might be, for example, a cash flow hit if you're making a settlement offer over time. So it's really important to not just think about the ultimate decision maker, but to think about the other parts of the business that are going to be affected by settlement decision. So external counsel really need to know the commercial drivers of a dispute. In particular, they need to understand what the risks and opportunities are from the business perspective. They need to understand if the dispute has a huge impact to the way the business operates, or whether it's a fairly minor thing and it's either a small risk or an opportunity. Knowing that, different strategic approaches can be taken and different care and balances can be implemented in how you manage the dispute and the litigation. Understanding the universe of the materials and evidence relevant to the dispute and litigation is extremely important. Unless your business has a clear policy on who swears affidavits and who will swear witness statements for the purpose of litigation or a dispute, a lot of businesses tend to turn straight to their managing director or senior management to provide that evidence. However, they might not be the best people to provide that, and for strategic reasons, you might want to involve them in the dispute. For example, if you've got a dispute about an incident, you want the person who was actually there at the time of the incident, who witnessed the incident, who can speak to the incident and provide context. If you've got a dispute about whether a contract means one thing or another, you want the person who potentially wrote the contract, but you also want the person who was there negotiating it before and also the person who was using the contract after to provide some context about why we say or you say it's interpreted in a certain way. The other thing to be mindful of is if you keep the information and evidence gathering process to a later stage, you might discover that one, your evidence is not as strong, two, the person who needs to provide that evidence or information is potentially no longer in the business, or number three, you haven't retained that information and information you thought that existed didn't in fact exist. A couple of processes that I recommend to ensure you can manage the discovery process are, number one, ensure you have a legal hold policy or a legal hold direction. What that means is a communication from you or from the legal team to the business to say, we've got a dispute on foot, you need to hold and maintain these documents and records, please do not delete them. That's really important because while you're going through the discovery process, the worst thing that could happen is you discover a document to only then realize later that you no longer have it when the other side seeks it from you. The second tip I'd recommend is to ensure that you work very closely with your IT teams and you do so from the start. So with the discovery process, as all of you would experience with your businesses, it involves more than just looking through hard copy files, and it does involve documents that have been archived elsewhere, but also that could be on old computer systems, servers, folders, etc. And accessing that can be a challenge, obviously. So it's really important to have your IT teams aligned with you early on, and for them to be aware that during a discovery process, you will be leaning on them very heavily and when required. And thirdly, the last step or process I think you need to have in place is a retention policy. And if there wasn't one, to implement one immediately for your business to ensure that you can show that you've actually retained and your business has properly retained all information if in the event your discovery is ever challenged. Legal professional privilege attaches to documents and communications created for the dominant purpose of legal advice or for litigation. Your role as in-house legal counsel is to really manage and protect legal professional privilege before and during a litigation process. So quite often LPP can be waived just by too many people who don't need to be involved in the matter obtaining copies of documents, obtaining advice that was given to the business that not relevant to them, or seeing communications once again, or being part of communications where LPP attaches. So it's really important to have a tight team working on the matter and to have really clear protocols to ensure that everyone's aware of what they can be saying, what they can be passing on, and when not to pass on information. And if in doubt, to speak to you so you can manage the process.